Justice Sotomayor? Justice Kagan?
Mr. Talent, I have a sense that this whole suit is a little bit of it's like in search of a problem. I mean, in fact, we all the time allow suits pre-election to challenge election rules. I mean, there's hardly an election rule that gets passed in any battleground state that isn't challenged. It's usually by a party. And we've, I think always allowed those kinds of suits because the party has suggested in plain English, and it's not so hard to do, why it is that the new rule will harm them, why it is that, they would prefer the old rules in terms of their electoral status. So why isn't the same thing true here? I guess I just sort of think, what's the problem here?
The problem here, and what our rule gets to, is the fact that candidates are forced to gamble that these ballots are going to affect the outcome of their election.
I don't think we've ever actually asked the RNC or the DNC to do anything like that. What we've asked the parties to do is and this is why you don't get these cases thrown out on standing grounds, because there are perfectly easy ways for a party to say why a new rule is going to harm them in the electoral game. When Sunday when Sunday voting is shut down, the Democratic Party rolls into court and says this is going to harm us, and the suit goes forward. And similarly for the Republican side on different kinds of rules. I feel as though we're asking to create a whole new set of rules when everything has been proceeding just fine. That everybody who actually is harmed or is likely going to be harmed by a new election rule has had the chance to sue.
So our rule addresses a situation where a candidate is coming in and ex ante. They're being forced to gamble on whether
all of
or
these
not
suits are ex ante. Every time we have an election, every battleground state, we get to see how litigation plays out, mostly brought by the RNC and the DNC prior to the election, asserting that a new rule is invalid for some reason or other. And those suits are never tossed because of standing, because there are easy assertions to make in a complaint about why a new rule is going to hurt you in the electoral process.
I think a candidate can make those allegations here with a based on the fact that these rules govern the counting of votes in their election. They're forced to gamble that these rules are not going to affect the outcome. So whether, as to the competitive injury, just to kind of make an example, even though that may benefit them, they still have to put on the line their concrete risk at winning because it may not benefit them. It's different for the RNC and DNC because I don't think they as neatly fit into the paradigm of being a direct object of these rules. It's really the candidates because these rules are targeted at their electoral success.
Justice Gorsuch?